All right. Let's see, one administrative matter. I think juror number 11? 12. During jury selection, you'll recall that she mentioned a hearing that she had, administrative law court proceeding in Harnett County. It's actually scheduled for tomorrow. She brought the paperwork in. I'm having my judicial assistant contact and see whether we can get that continued. I don't expect it'll be a problem, but I just bring that to your attention because we're making efforts on her behalf. The next thing, I received information from the SBI last night in response to this was delivered by Joy Strickland, Deputy General Counsel. Is Ms. Strickland present in the courtroom?
I don't believe so, Your Honor.
No, sir.
All right. This is in connection with the internal investigation relating to the portal, the placement of 2 documents in the portal that was accessible by the District Attorney's Office in District 9A. And I've reviewed those documents in camera. I sent an email, I believe both of you were copied, as well as, or I directed that an email be sent, as well as a copy to Ms. Strickland, indicating that after review, in balancing both the relevancy of this material, which I'll state I find fairly minimal. There may be some relevancy to some issue, but balancing the relevancy and the probative value, also the personnel matters that may be involved in this investigation of state employees employed by the SBI, as well as the due process rights of the defendant. I've made the determination to release 5 pages from this file. There's approximately another, 30 pages that are also in this file. And I'll simply say that what I'm releasing is the synopsis of the investigation and then the final conclusion of the investigation, as well as a cover page. I believe the synopsis fairly characterizes the entire investigation. I have reviewed the entire investigation, so in balancing all those things, I find it appropriate to release these 5 pages. I invited Ms. Strickland, should she have any objection to the release of these, to be present at 9:30 today when I was going to take this matter up. I see that she's not here and she's not contacted our office, so I'm assuming that they have.
I think she
responded.
copied us on an email. I think I agree with the state. She didn't object to your ruling, but there was a line that followed that about it being a limited disclosure, and I interpreted, and I don't know if the state did, that before I used it in open court that there would need to be another phase. That's the way I interpreted the email. I'll let Mr. Latour.
Yes, I've got the email pulled up and I can relay it to the court from Joy Strickland this morning. She responded to the email that you sent and said, "Thank you for the information. I will be unable to attend court at 9:30 as I am in Sanford today, but I do not have any objection to the release of the pages that you reference in your email to the parties. I would ask that the dissemination be limited to the parties for the use in this litigation only because it is confidential in nature. Thank you."
That sounds fine. I'll certainly order that it be limited to use in these proceedings. And why don't, after you've had a chance to review it, if you do intend to, either the state or the defense intends to go into this, then we can certainly talk about how we can redact portions of it if there are names or other identifying information that is not essential. But in any event, so I will provide copies to multiple copies. So I'll just take 2 each if you. And what's that? Yeah, and what I'll do with the remainder is I'm going to simply seal the balance of the file, and we'll make that which I did give you part of the court record as well, and that way we have a record of this transaction. I think since you've read the email into the record, I don't think we need to print anything out on that. I think this would be appropriate just to give this to the clerk as it stands. I'll certainly give you time to consider this. If you want to do that now, that's fine. If you have other matters that we can take up, we can take those up now, and then I'll give you time to review it before we bring the jury in.
I don't have any other matters. I'd just like a few minutes.
Okay. Mr. Latour, did you have any other matters?
No, Your Honor.
Okay, take a few minutes to review it, and then once you've had a chance, we'll go ahead and either hear from you further or bring a jury in.
Your Honor, I asked the court for guidance in terms of if there's anything else that the court feels like they could reveal from the packet in some redacted form. I recall the event of receiving Defendant's Exhibit 30, which I put before the jury, and it is accurate that it was received in November. I do not know what number 76 and number 74 is. From the defense standpoint, I would like to know what that is and how it was determined that that was downloaded or printed. When I get to the part of the interview of a member of my staff, it is a little bit unclear as to, I mean, I know what was presented. It was Defendant's Exhibit 30, but in the actual narrative of the synopsis, it doesn't really say other than the file. So before I could effectively cross-examine Agent Whitley, and in fact, he may not know anything about that. I'm just trying to resolve this factual dispute in this synopsis about, I know that Agent Whitley's already testified that he thought that we got 2 interview statements, and of course I contend we got this investigation cover. I guess just as a little bit of further argument for the defense, receiving that was consistent with, well, let me say this. I dispute the fact that Agent Whitley had identified me as a subject. However, clearly, upon receipt of this cover sheet and looking at it, I saw that. And at that point, I did seal that document and set it aside and directed my staff to do nothing else. So I just don't know what 73 and 74 is, and I don't know what made the SBI conclude that we got it, and I'm just trying to discover those facts. If there's anything in the file that could reveal that, and again, I'm not seeking any personnel information in terms of who at the SBI did this beyond what the synopsis said, I still kind of would like to know what it was.
Right. I can tell you that I could not find anything in the file that identified what those documents were. And I don't want to spend a great deal of time on this because I understand your point and your curiosity, but I'm not sure how relevant any of this information is. I certainly can go through it again and identify documents that that track when documents were posted and when they were released, and even to who downloaded them and accessed them. I mean, there are screenshots that illustrate that, and so those are things that I don't think are particularly proprietary or confidential, but they are what is the basis for the SBI's ability to track what goes into the portal, what is released from the portal, and by whom and to whom. And so that is available, and I think that could be released as well.
And I won't introduce it. I just want to review it to see if I can make sense.
All right.
I don't care. My only concern is the information that was released to Joy Strickland that she consented to, and the basis for her not being here was her understanding is what you were releasing is what you were releasing. If now we're releasing more information, that may be something that they want to
Right.
be a party to. Again, to me, it doesn't matter, but it's not my information that's being released.
Right. And that's my concern is that, I have reviewed the documents. I think the synopsis provides a fair characterization of what occurred, the investigation, the documents that were released to the extent that they're identified in the materials are by the same numbers that appear in the synopsis. The synopsis accurately reflects and is corroborated by other information in the file, and including, like I said, screenshots that show the ability of the SBI to track documents that go in and out of the portal. If you desire more information on that, I'll be happy to try to review the document again with that question specifically in mind as to the identity of the documents that were released, and provide notice to the SBI that I intend to release it or not release it, and give them an opportunity to either consent or be heard or waive their right to be heard.
Yes,
and
sir.
provide that to you. But I'm trying to do things expeditiously, but also with a view towards utilizing the jury's time efficiently. We have a witness on the stand who we need to continue examination of.
Yes, Your Honor, just one point of clarification. Is it within the file that's sealed anything that identifies, even by screenshot, what 73 and 75 is?
I was unable to find that.
Okay.
The screenshot only reflects there is nothing from which I can discern any identification of what the contents of those documents were. They're identified throughout the investigation exactly the same way they are in the synopsis as by the numbers that you have.
Yes, Your Honor. Would I be violating any of yours or the state's or Ms. Strickland's concerns if I asked Agent Whitley, or would you prefer I stay away from that till I talk with the SBI?
I'm not, if he can identify, if Agent Whitley can identify what those documents are, it's not within this file, so it's not
Right.
something that I have a concern about.
Yes, sir.
In the narrow review that I'm doing with respect to these files, balancing all of the issues I need to balance.
Yes, Your Honor.
If
Thank
he
you.
knows and you want to ask him, that's fine. I do forecast one other issue that relates to this, and that is that there is a reference to another agency that is the reason, I think, that in the synopsis that is given for why this error occurred. And so Mr. Latour may seek to go down that path if you inquire too deeply into this matter. So I would just urge you to bear that in mind.
I certainly will, Your Honor.
All right.
I do have one question, unrelated matter.
Yes, sir.
To get back into the cross, I was going to ask a question with regards to the October 19th meeting, and you gave me direction from the voir dire hearing, and I wanted to make sure it was accurate. Is it appropriate for me to ask from the October 19th meeting, you were aware that I had concerns with regards to how the investigation was being conducted? Is that consistent with your ruling, or have I got that wrong? Because we had the voir dire, and you
Right.
gave me that direction right at the end of the argument, and I didn't want to step over the line on that issue.
My notes were that in the voir dire, the Agent Whitley testified that he recalled that you expressed concerns about the investigation, is what I've written down. I believe you've already asked him that question, and he gave a response or confirmed that he recalled that topic was discussed.
Yes, sir.
I don't know what more he can say about it.
I understand.
But I think it's been asked. I think he's given a response in front of the jury as well as in the voir dire, and my notes reflect that the topic was concerns about the investigation.
Yes, Your Honor. It was simply going to be a transitional question. I wanted to make sure I didn't ask it in the wrong way.
All right.
Nothing else.
Okay, very good. Mr. Latour, anything further?
The only thing that I kind of am gleaning from all of this that might be an issue, and based on Your Honor's comments and what I anticipate future objections to be, if we're going to go down this road of this investigation, my recollection of the testimony yesterday was that the witness didn't know anything about the investigation, didn't know anything about, and that those questions have already been asked and answered. I would inquire of the court if you think it more prudent, if that's a line of questioning that the defendant wants to go down that in a voir dire, so that we don't get into those issues in front of the jury, which may not be relevant at all, and we have to go through and have a 15-minute objection-filled conversation as opposed to just getting it all out during the voir dire, determine if it's relevant, and move on from that point. But I leave it to Your Honor's discretion.
Well, Mr. Bradsher, do you intend to make inquiry into this investigation? And if so, I'll hear why you think it's relevant, and I'll be glad to hear from the state why they don't. I've already expressed that I think it has limited relevancy, but...
Right. I don't plan to plow any ground that I've already plowed. And I don't think that I'm going to elicit any questions with regards to something that's inadmissible. The state has put in Judge Crosswhite's letter and introduced these phone calls and restated things Craig and Cindy Blitzer said. My questions are fairly limited around the issues that the state raised on redirect.
All right. Very good. Let's just proceed that way. And if you feel a need to go into this, then I would anticipate an objection, and whether we need to do it outside the presence of the jury or not, we'll just make the call when we get there. All right. Very well. Very good. Let's bring jurors in. All right. Good morning, ladies and gentlemen, and apologize for the delay. We took care of a couple matters outside of your presence, so we could go ahead and get underway. At this point, I believe we're in recross of this witness, Agent Whitley. Agent, do you recognize you're still under oath?
Yes, sir.
All right, very good. Mr. Bradsher?
Thank you, Your Honor. Good morning.
Good morning.
Agent Whitley, following where we stopped yesterday, we were talking about the October 18th phone call. Is that right?
The October 18th phone call?
Right. Do you recall us ending yesterday about this phone call that Mr. Latour discussed on October 18th
Yes, sir.
around 7:11 p.m.?
Yes, sir.
All right. And you identified that as a phone call between two phone numbers and lasted about 30 minutes. Is that right?
Yes, sir.
Okay. So to establish the chronology, you and I would have spoken by phone on August 10th, wouldn't we?
I don't recall.
Okay. And then we met September 6th. Is that right?
Yes, sir.
Okay. And then I called you again on October 6th. Is that right?
I don't recall the date. I remember you calling me about a media inquiry.
All right. And then you told the jury about our meeting on October 19th. Is that right?
Yes, sir.
And that was the meeting, isn't it true, that there was expressed concerns about the investigation and how it was being conducted? Is that right?
I recall you expressing concerns about the investigation.
All right. And I already asked you, in terms of the specifics of that, you had indicated you don't recall.
I do not.
Okay. So as to Craig and Cindy Blitzer, they related to you that this phone call about resignation, where Cindy Blitzer contends she offered to resign, that it was at the height of the media. Isn't that right?
I would like to review that.
Sure.
I don't remember the specific language, but I remember something about she had heard about it in the media
All right.
or read about it.
Your approach, Your Honor.
Yes.
Handing what's been marked as Defendant's Exhibit 37. Just take a moment and read that to yourself.
Yes, sir.
Now, in reviewing that, does that refresh your recollection as to the first media outlet to break the story was the Greensboro News and Record on October 28th of 2016?
Actually, I do not know who the first media outlet was to break the story. I don't know when the first story broke, but I can tell you that this is one of the media articles on the subject.
And in fact, you would have documented a link to this particular article in your email that you provided in discovery when it came out October 28th of 2016. Is that right?
I would have documented anything I received by email, yes.
Okay. And then in terms of sequence of events, you know that Cindy Blitzer was let go October 24th. Is that right?
Yes, sir.
Prior to this October 28th article. Is that right?
Yes, sir, that would
Okay.
be correct.
And then you described yesterday to the jury about going back to Judge Crosswhite in December, and then there was a letter to the Attorney General's office. Is that correct?
I don't recall when I would have met with Judge Crosswhite again, but I know that we've talked about a letter that was sent.
All right. May I approach the witness?
Yes.
Agent Whitley, I'm handing what's been marked as Defendant's Exhibit 38. Same thing, if you could just review that and see if it refreshes your recollection.
Yes, sir.
All right. In terms of now having your recollection refreshed, do you recall that there was a December 7th letter from Judge Crosswhite to the Attorney General's office after you had met with him concerning the investigation of the Cindy Blitzer putting in hours that she wasn't working?
I can tell you that I see that letter referenced in this media article. I don't independently remember that letter. I don't know whether I ever received a copy of it. If I did, it would have been put in the case file.
All right. But you were monitoring media, is that correct?
I think monitoring the media would be a little strong. I
Okay.
was aware of it.
All right. Now, may I retrieve State's Exhibit, Your Honor?
Yes.
Your Honor, may I ask if the witness could step down towards the jury? One day, have him point something out on State's Exhibit.
All right. And what exhibit? It's
It is
State's Exhibit.
State's Exhibit 14. It was offered on redirect.
All right. Yes, that's fine.
Thank you. Agent Williams. If you could point out to the jury on State's Exhibit 14, what is the date of this letter that the state has introduced on redirect?
Date is in the middle upper and reads July 25th, 2016.
And if you could slide back a little bit and show them as well.
Yes, sir.
All right. Now, with regards to that letter, State's Exhibit 14, if you would show the jury who it's addressed to.
It's addressed to Director Schurmeyer, who is the director of the SBI.
All right. And as Mr. Latour did yesterday, could you also point where the three names are listed in the letter of Cindy Blitzer, Jay Stoltz, and Wallace Bradsher?
So Ms. Blitzer's name is listed. Mr. Stoltz's name is listed, and Mr. Bradsher's name is listed.
So if you, as you have testified earlier, this is the requester letter that gives the scope of the investigation with regards to Cindy Blitzer working hours and what she's putting in Beacon. Is that right?
That's my understanding, yes, sir.
And from your recollection prior to the entry of this letter, did you personally speak with Judge Crosswhite by phone or in person?
I spoke with him by phone.
All right. And just to refresh everybody's memory, the three issues that started with April 6th interview of ADA Ramey that led to you was the Tyler Henderson issue with regards to law school, which was set aside within a couple of days. Is that right?
Yes.
And the second issue was the Cindy Blitzer putting in hours that she wasn't working. Is that right?
I think it would be safe to say there were multiple reasons, and this was one of them.
Let me ask you to resume your seats, if you would.
Well, the April 6th interview was about those three things. Isn't that right?
I could review that again, but I know in general there were multiple concerns that he had and expressed to Agent Mays, and this issue was one of them.
All right. Did you relay facts to Judge Crosswhite for the creation of this letter in State's Exhibit 14?
I did.
Okay. Then, did you go on vacation?
Yes.
And then Agent Mays sent a memo laying out the facts to support the requester letter for State's Exhibit 14. Is that right?
Sent a memo to whom?
Judge Crosswhite.
I know that Agent Mays had contact with Judge Crosswhite during the time that I was on vacation. That memo very well could have been part of that. I don't know.
All right. And isn't it true that State's Exhibit 14 is not the first requester letter that you got for the investigation of Cindy Blitzer being accused of putting in hours that she didn't work?
That is the first official letter. I believe there was a draft letter.
You explained that, I believe on Friday, that you said Judge Crosswhite had never done one of these before or wasn't familiar with the process, something to that effect?
Something like that.
All right. And you guided him a little bit in terms of what to do, is that right?
I'm not sure I got it. I have
Okay.
not done it either.
All right. Well, do you recall that when you returned from vacation, that Judge Crosswhite had sent you a letter that he had drafted and labeled the Blitzer document, with the scope of the investigation being Cindy Blitzer and any other persons involved in both offices with regards to Cindy Blitzer putting in time in Beacon that she was not working?
If that was included in the draft letter, I'm aware that there was a draft letter, and then I'm aware that there was a letter waiting for me at headquarters.
And there was an email from Judge Crosswhite to you, wasn't there, with this draft letter that was different than what is State's Exhibit 14, isn't that right?
The draft letter was different than that document.
You had a chain of command, is that right?
Yes, sir.
And you sent that draft letter, as Judge Crosswhite had proposed, to your supervisor, didn't you?
I would have forwarded it to someone else to deal with while I was on vacation, yes.
Okay. And now we're around August 1st, isn't that right?
The letter was, I believe the letter may have been received at headquarters around then.
All right. Well, after you sent Judge Crosswhite's initial letter to your supervisor, isn't it true that your supervisor reached back to you and indicated that there needed to be changes to the document?
I don't specifically recall.
We talked earlier that the supervisor in Greensboro as of December of 2015 was who?
The supervisor at that time was Special Agent in Charge, Scott Williams.
Okay, Scott Williams. And we've already told the jury that Jason Ramey met with another SBI agent prior to April 6th regarding this issue, right?
That is correct.
Isn't it true that after Judge Crosswhite did the initial letter, that at the direction of your supervisor, Tommy, the supervisor, and Agent Hayes were going to discuss revisions to Judge Crosswhite's letter?
Agent Hayes?
Sorry,
Or
Mays.
Mays. I don't know what the progression of those events would have been. Like I said, I was on vacation, and I just don't know.
So do you know who typed the revised letter to send back to Judge Crosswhite?
No, I don't.
But States 14, when it was emailed to you, it changed to, from the Blitzer document to the Bradsher document. Isn't that right?
I don't know.
Okay, fair enough. May I approach the witness?
Yes.
Hand you a packet, Defendant's Exhibit 39. If you could take a look at that for a moment to see if it refreshes your recollection in terms of the sequence of events.
Yes, sir.
So having reviewed that, does that refresh your recollection that Judge Crosswhite's letter with regards to this investigation of Cindy Blitzer putting in hours that she did not work, it was changed at the direction of the SBI?
I can tell you that my supervisor at the time, Zach K. Perry, wrote an objection.
Sustained as to what was said, but you can answer the question.
I'm sorry, ask the question again, please.
Sure. You were directed by your supervisor, Zach Perry, to coordinate with Agent Mays with regards to the revision of this letter. Is that right?
No, sir.
Okay. You didn't have any part in revising Judge Crosswhite's original letter. Is that right?
No, sir.
That was done by Agent Mays in consultation with the supervisor, wasn't it?
Objection. Sustained.
Okay. If you could look in that packet to the memo sent to Judge Crosswhite from Agent Mays. Very beginning.
Yes, sir.
All right. Just look over it. What was sent to Judge Crosswhite by Agent Mays on, do you know what date?
The document I have in front of me is Monday, July 25.
Okay. As you look at that, the facts submitted by Agent Mays relate to Cindy Blitzer. I'm trying to do it as a category, Your Honor.
Well, sustained, and I'm not sure that he has personal knowledge of any of this, so there's a foundational issue on that. Anything, it seems he's testified to that, so I'll need some foundation as to what his personal knowledge of these events might be before I'm going to allow
Yes,
any
sir.
of it in.
Agent Whitley, when you came back from vacation, you looked at the document that Agent Mays had sent Judge Crosswhite as a basis for the requester letter, isn't it?
Yes.
Okay. And you relied on that in terms of your next step with regards to this authorized investigation of Cindy Blitzer putting in hours she wasn't working.
And you're talking about the document that was sent to Mr. Schermeyer.
The memo sent to Judge Crosswhite from Agent Mays.
Oh, I'm sorry. That was some of the information that we yeah, definitely looked at in the beginning of the investigation.
And that completely related to Cindy Blitzer and the Beacon hours, but did not include anything about
Objection.
Overrule.
Rockingham staff taking courses for Ms. Blitzer. Is that right?
Yes, sir, one moment. Yes, sir.
But yet the first interviews done beyond AOC was with Jason Ramey on August 29th and Spencer Morrow, which included details about taking courses in Rockingham County.
Yes, sir.
Okay. During the course of your investigation, you did learn that from April 10th, when you first contacted me, through Cindy Blitzer's termination, that I had contacted Jay Stoltz, her direct supervisor, didn't you?
Objection.
Abstained as to what was said.
Okay. You were able to confirm that I spoke with at least Craig Blitzer, isn't that right?
Yes.
On several occasions, isn't that right?
I don't recall specifically.
All right. From your investigation, were you able to determine that I also made inquiry as to whether or not Cindy Blitzer
Objection.
was working?
Sustained.
You talked about yesterday the computer that hasn't been tested. During the course of the investigation in August, based on your interview within this investigation authorized by Judge Crosswhite as to whether or not Cindy Blitzer was working the hours she was posted, you learned of 2 computers removed from Rockingham County DA's office, didn't you?
I learned that, and I don't recall whose interview it was, but I learned that computers were switched out of that office at some point.
Okay, and that's something you investigated?
That's information we received during the course of the investigation. I don't recall now what we did with the information.
And once Cindy Blitzer was terminated from employment, did you go and review state documents with regards to her discharge and her final approval of Beacon?
I don't recall now off the top of my head.
Okay. Thank you. And in terms of the packet that I had you look at, Matt Brooks,
Yes, sir.
would you agree that this is a chronology of events with regards to yours and Agent Mays and your supervisor's interaction with you and Judge Crosswhite with regards to this requester letter?
I can tell you that these are emails between some of those parties and then some other parties. And there are dates that are included that would document some of these interactions. I'm not sure if I could call it a what you said.
Was the investigation into Spencer Morrow and others taking courses for Ms. Blitzer part of this requester scope of the investigation in State's Exhibit 14?
In my mind, it was, and
Okay.
we,
All right. Mr. Latour showed you some phone records. You were also able to confirm that on the date of Ms. Blitzer's termination, there was a phone call from my number to Craig Blitzer's number around 1:15. Isn't that right?
if I could see that document again, that would be helpful.
Okay. You don't recall that?
I looked at a lot of stuff yesterday.
I understand. And did you look at the records then, about 30 minutes later, between Gail Peed and Ms. Blitzer?
Are we talking about phone records again?
Yes.
I would certainly like to see that and have it in front of me before I answer questions about it.
All right. Okay. Thank you very much. Nothing further.
All right, thank you, sir. Yeah.
I have
Did
a
you
few-
have further questions?
I do, just
All
a
right.
few, Your Honor.
All right, very limited.
Yes, Your Honor. May I approach?
Yes.
Approach with State's Exhibit number 15, which you identified yesterday.
Yeah.
You identified that yesterday as phone records, correct?
Yes, sir.
Now, on cross-examination of you yesterday, there were some issues raised about the phone number that ends in 76, correct?
Yes, sir.
And whether that was a cell phone or a home phone or what that is.
Yes, sir.
Have you, over the evening and the course of your investigation, been able to review all of your notes and all of your reports about Craig and Cindy Blitzer?
Yes,
Now, when you did that, did you look for telephone numbers?
I did.
And anywhere in your reports or your notes, does it indicate that that number that ends in 76 is Craig Blitzer's cell phone?
No, sir.
Okay. In fact, in looking at your reports, what do you have as Craig Blitzer's home phone number?
336-347-0176.
And for Cindy Blitzer, in your reports, what do you have as her home phone number?
336-347-0176.
All right. And the records that you testified to yesterday in State's Exhibit 15, what number are those records for?
336-347-0176.
And may I approach, Your Honor?
Yes.
Looking at that document, is there a page which kind of lists subscriber information?
The second page of the document.
All right. And does it have an address that's attached to that phone number?
Yes, sir.
What's the address that's attached to the phone number?
2, one word, Lane, Reedsville, North Carolina, 27320.
Do you know whose address that was at the time of those phone records and that telephone call that we've talked about on the 18th?
Yes, it's the residence of Craig and Cindy Blitzer.
Now, on that subscriber information, does it say home phone?
Yes, sir.
And what's the home phone number that's listed there?
336-347-0176.
So yesterday when you testified that you thought you had that as a cell phone number somewhere for Craig Blitzer, is that accurate?
That was not accurate.
Okay, and were you able to verify that over the evening?
I was.
Okay. Is there any doubt in your mind that that was a home phone and a cell phone?
No, sir.
Okay. No further questions, Your Honor.
Mr. Bradsher?
Yes, Your Honor, may I approach?
Yes.
First, do you have Cindy Blitzer's statement?
Yes, sir.
Mr. Latour asked you, in all discovery, there's no other number. But what did Cindy Blitzer say the number was she called from on October 18th?
In the body of the report, on page 18, second paragraph, she lists her home number as 336.
Okay. That's not the number that's involved in the October 18th.
That is a different number.
And Mr. Latour was just asking about this. Sure, this is a home number. Isn't it true that this particular printout shows a home number, a digital phone, and an email? Is that right?
It says digital phones 336-34 phone 336.
And then an email address. What is that?
Craig Blitzer at gmail.com.
And in response to the administrative subpoena, the name assigned to that number is what?
The name on the account is Craig Blitzer.
Okay. Yesterday, you indicated that this October 18th call, you believed corroborated the call that Cindy Blitzer described to you, is that right?
That's correct.
But in terms of going back to her and sitting down, or Craig, and saying this is the day it happened, you didn't do that, did you?
No, sir.
Okay. And have you looked at other calls with regards to that digital phone number on whether or not it was actually used away from the home?
I'm not sure I follow you.
Right, well, there are mechanisms in terms of subpoena about regions that you're in when you make a phone call, isn't
Oh,
it?
you mean like cell phone tower analysis?
Like that.
No, we did not look at, there's no indications that that is anything but a home phone.
Based on that record, right?
Yes, sir.
Nothing further.
Thank you, sir. You may step down. Further evidence for the state?
Yes, Your Honor, may we approach?
Yes. Ladies and gentlemen, there's a brief matter I need to take up outside your presence, but as you'll recall, we're breaking for lunch at noon, so why don't we take a brief mid-morning recess until 5 minutes till 11 and gather in the deliberation room at that time. Please recall the instructions and rules I've given you. Leave your notepads and materials in your chairs and gather in the deliberation room at 5 minutes till 11. Ms. Latour, who is your next witness?
John Stoltz.
All right. Mr. Stoltz, could you come forward, sir? And just come up to the witness stand, sir. Judge Stoltz.
Yes.
Is that correct? Yes, sir. Judge Stoltz, I wanted to talk to you about your testimony here today and specifically your Fifth Amendment privilege against self-incrimination. Make sure that you understand that. Do you intend to testify in this case?
I do, Your Honor.
All right. I wanted to let you know that if you do choose to testify, you'll be waiving your constitutional privilege against self-incrimination. And what that means is that you'll be required to answer truthfully to questions posed to you both by the prosecutor and by the defense in this case, even if those answers may tend to incriminate you or otherwise be contrary to your interests. Do you understand that?
I do, Your Honor.
All right. Now you're a district court judge, is that
Yes, sir.
correct? You have a law license in North Carolina?
Yes, Your Honor.
Yes, sir. So you understand the Fifth Amendment and the implications and ramifications of your privilege against self-incrimination, is that
I do,
correct?
Your
All right. You've not been charged with any offense in connection with any of these matters, is that correct?
No, Your Honor.
All right. So do you have any questions for me about the scope of this privilege or any obligations that you may have in the event that you choose to testify?
No, Your Honor.
All right. Then either of you wish to be heard any further on this matter?
There you go.
No,
All
Your
right.
Honor.
I'm going to find that you have understandingly and knowingly waived your privilege against self-incrimination, that you've elected to testify voluntarily in this matter, and that you, like I say, that the privilege has been waived if and when you do testify in connection with this matter.
Yes, Your Honor.
All right, very good. Thank you, sir. You may stand down. We're going to take a 10-minute recess, and we'll resume at 10 minutes till 11.